Hello, everyone. I'm Dwight Mitchell. I'm the president of Family Preservation Foundation, and welcome to another episode of our Child Protection Services Pro Se Video Help Kit. Today, we're going to talk about disposition through permanency. That's if you've had your trial and they found you guilty of child abuse, and then through permanency, through the end. So we're going to talk about what happens as it relates to that phase on the timeline. I hope you enjoy the content and it allows you to better understand your rights and options as it relates to CPS and helps you in your battle as you move forward. As some of you may or may not know, if this is your first time tuning in, because the series, you can pick and choose what video you want to look at. For those of you who don't know me, after a 22-month battle, I successfully defeated Dakota County Social Services to regain custody of my children pro se. It was a traumatizing situation filled with a lot of anguish, but I was able to learn a lot. I filed a lot of motions, did a lot of reading, had a lot of case law, and so what I'm going to do is pass along the benefit of my knowledge and my lessons learned while cross-referencing the Minnesota state statutes and the case law that's applicable, that's readily available on Google Scholar, and to tell you how to go about doing what you need to do to protect your family. One of the disclaimers that I have to make, and I'm told I have to make this at the beginning of every one of my sessions, that I am not an attorney, nor am I licensed to practice law, nor am I providing legal services. I recommend you to obtain your own attorney if possible. I have a section in my video learning series, Working with Your Attorney. I advise you to read that. It's very helpful and beneficial. It's probably one of the most important units in the beginning when you first start getting involved with CPS, so that you won't be misguided like I was by an attorney's legal strategy or incompetence and or greed. You should always check references on your attorneys. Don't just let them say that they're a child investigating specialist. I mean, you can actually look up the attorney at the courthouse on the docket and see what kind of cases they are working on and whether or not they really are child protection services and how many cases they actually won. So I'm going to speak to some references also. So this video series is for educational purposes only. I will go over the beginning, the middle, and the end of the CPS process and what you can do in your defense or fight against CPS. This is going to be hard work. Make no bones about it. Nothing worthwhile in this world comes free. You're going to have to do some reading. You're going to have to do some writing, filing motions. But it's all for a good cause. It's for your children and your family, and that should be the most important thing to you. The reason we're all here is to get our children back. So you're going to have to do your own court filings, and you're doing this pro se because you don't have an attorney, and pro se by its very nature means for myself, so you can't go into court and say, well, so-and-so told me to do this, or I read this, and I'm doing that. You got to read the information, digest it, understand it, and then you need to write out what's applicable to your case, because every single case is different, and so you please keep that in mind as we go through this. So hearings that you've had to review and disposition is what we're really going to go over. The Minnesota Juvenile Rules of Procedure, if you go to 41.06, hearings to review, disposition, subdivision 1 talks about the timing and when this should take place. So when the disposition is to award legal custody to the responsible social services agency, that's after your trial, the court shall review the disposition at least once every 90 days. Any party or county attorney may request a hearing sooner than 90 days, but at a minimum, it should be every 90 days when social services has protective services of your child. The court is required to do one at the 6-month time frame also. So keep that in mind. 90 days, maximum of 6 months, you need to have a hearing where they're reviewing what's going on with you and your child in the case plan. If we go to Rule 41.06, subsection 2, procedures in the review disposition hearing, point A is they talk about legal custody of the agency and having that child in foster care. So, when the disposition or the trial says that the child is to remain in custody and we're transferring that child to foster care, they're going to give an order to that effect, and then they have to schedule reviews to happen every 90 days. So this is after your 60-day trial. The topics to be reviewed by the court are going to include the out-of-home placement plan, what most people just call the case plan, reasonable efforts of the case plan, whether it's been effective, whether it's been working, whether things are positive or negative, what's the disposition at that time, and how's the child's well-being. Is the child well-adjusted? Are they acting out, saying they want to come home? So all of that's supposed to be reviewed at that time. Rule 41.06 subdivision 3, any party can request a modification to the plan. The county attorney, yourself, if things aren't working out well. Say you have a provider that you don't get along with, you can ask the judge to give you another provider, or if you're not getting enough visitation, you could talk about more visitation. So anything in that plan that's before the court, you can ask for a change just by petitioning the court with a motion. Hearings are generally conducted in an informal manner, and they're designated to facilitate the opportunity for all parties to be heard. So don't just sit there quietly, at these depositions if you don't have an attorney. You're supposed to be writing oppositions, and you're supposed to have notes done. So when the social worker and guardian ad litem file their court report, you should have a court report that you file also. So if they give you that court report 5 days before, within 5 days, you have to file an opposition or whatever it is you want to say, send a copy to the court. Social worker, guardian ad litem, county attorney, make sure everyone has a copy. So when you get to court, you can all talk about it and no one can come and say, well, I don't know about it. We're going to have to postpone this for another 90 days to the next hearing. That's how they get you every single time. They don't give you time to respond, and then when you do try and respond, they say, well, it wasn't in advance, and then they say, okay, well, we'll look at that in 90 days down the road, which is something you don't want, and it's not advantageous to you as a parent. The court can admit any evidence at the hearings that it wants, any relevant, anything that's reliable. They can use hearsay, but they rather have things that are formal. And when I say hearsay, if you bring in a witness to something that witnessed something, you can bring that in, and that's admissible at court, as long as it's relevant to the disposition. You can't bring in something when they're talking about A and you bring in something about B over here that has no bearing on the hearing or your child. So it has to be relevant to that disposition or that topic. They want to see if things are going well with the case and what can they do to help. So whatever you can do to bolster your credibility or to highlight your strengths as a parent, you should be doing that in the hearing. If it's a counselor wants to come talk and say that you've been this super person, your pastor wants to come talk, you should bring these people to help bolster your credibility that you're doing well and you're working with the case plan. So you can do additional requests regarding visitation. You can want to increase your visitation, and you can say whether you want to have supervised or unsupervised visitation. Unsupervised means they'll give you your child, and you can take your child for 3 or 4 hours, and then you have to bring the child back. So that's something that they do allow, but you have to request that. Something you also need to do is like barriers to you completing and fulfilling your services, because social services in my time, they'll do things, in my humble opinion, that don't make sense. So they'll schedule you to go take a test like an hour away. And I've had so many parents say that, and they're like, well, I can't get to that. I don't have a car. So make sure that if you have a barrier to you being successful with the case plan, don't just like not go. If someplace is too far, make sure you write the court and say, Your Honor, they want me to go 2 hours out of the way. I have no way to get there, Your Honor. So if there's scheduling conflicts, they want you to go through a service at 2 in the afternoon, and you're at work at 2 in the afternoon, you have to bring that up also, so the judge knows that you're not just not going to the service. Your Honor, I'm at work. I can't go to that service at 2 o'clock in the afternoon, or I can't get off. If you have language barriers, if you speak Spanish or some other language and you don't understand what they're saying, you can get an interpreter for you. If you don't have insurance coverage to go to a doctor or a psychiatrist, you need to bring that up. And parents' overall access to the services. I mean, it doesn't do any good for a social worker to recommend a service if you have no way of getting to that service. So that's something to keep in mind, that you do have the right and the ability to bring that up in court. You can express your concerns about the child or the placement. If you're hearing things from your child that don't seem right or kosher, you bring that up. Bring up the things your child is saying. Any safety concerns about the placement, you can note that to the court also. Minnesota Statute 260.012, Subdivision 2, Section D, says that siblings should be placed together, at the earliest possible time. So if they've taken like 2 or 3 of your kids away and they have all 3 of them in different homes, in different environments, well, that's wrong. That's not what the state statute says. And please bring that up to the court and say, it's contrary to the safety or well-being of my children to have all 3 separated where they can't visit each other. Also, you can bring up whether or not the county has thoroughly explored using your relatives, because they're supposed to put the children with family first. The reason they don't want to put the children with family is because it cuts off their Title IV funding. So if you have a suitable relative, make sure you put that forward before the court and say, Your Honor, I have a suitable relative and I request that my child stay with my relative while I go through this process. If there's any factual disputes involving the report, so if the social worker's report or the guardian ad litem's report is inaccurate or is not stating the facts correctly, then you have a right to bring it up, and you need to point that out, and then you need to bring up your counter evidence and say, this is what their report says, but in fact, Your Honor, here are the facts. Here's the truth. What they're saying is simply untrue. Any additional services that you feel may be helpful, if you want to voluntarily take a dependency program or something, or you see something else that you think would help you get your kids back faster, you can talk about that also. They can also talk about a change in disposition if you are not cooperating. They might come back and say, Your Honor, we're trying to reunify this family, but the mother just flat out refuses to do anything. We just want to terminate her parental rights. So they can do that, or they can come and do the exact opposite. And Your Honor, we want to do THVs or trial home visits. So that's a change in disposition. When they start doing trial home visits, that means they're getting ready to close the case. They just want to make sure everything is going okay on the home front with you and the child. So I went over in one of my previous videos the CPS timeline and what needs to happen on that continuum of 1 year. I tell everybody, use the timeline to your advantage. Make sure you understand when every task and hearing is due and what's supposed to happen during that time period. That's the only way that you'll be successful, is to understand, well, here's the timeline, here's what's due, and here's what needs to be done, and I'm going to do it to make sure I get my child back. So what a lot of people have a hard time with is visitation. Visitation is a state mandate. Minnesota Statute 260C 178, Subdivision 3, parental visitation. They must give you visitation. The only time they don't give you visitation is for sexual abuse or egregious harm, where you hit the kid upside the head or you broke his arm or something of that nature. But everything else, it's a state requirement that they give you visitation, because they feel that visitation promotes the well-being of the relationship between the child and the parent. And if you're not doing it, it endangers the child's emotional well-being. So it's a mandate. So please keep that in mind. Look at the state statutes. If they ever try and tell you, no, you can't do visitation, say, no, here's the state statute. You have to give it to me. And if not, I'm going to the court to make sure I get my visitation. And write a motion to the court in order to get visitation. One of the things you have to remember is that the judge isn't there. He's supposed to be impartial, and he's not there to argue the case for you. You need to argue it for yourself. If it's a one-sided argument and CPS says 1, 2, 3, 4, 5, and you don't come back with facts to say 1, 2, 3, 4, 5 are wrong, the judge is going to just take it because it's a one-sided argument. And you're going to say, well, if you're not arguing, that means I must agree with what CPS is saying. So please keep in mind that you need to come back and, have discussions, make recommendations, talk about changes, talk about training or anything else related to your child. When a parent has no or limited contact with a child during the term of the case plan, they generally will move to termination of parental rights. They'll feel that you don't care about your child, you don't want your child, and it just gives them another excuse to help take your child that much faster. So, I recommend everyone, to visit their child as often as possible. And even though it's heart-wrenching, especially when you have to leave, like every time I left and my son kept wanting to go with me, and Daddy, I want to go with you, persevere. Tell your son, your child, it'll be okay. They'll be home soon. And but make sure you do as much visitation as possible. The frequency of the visits is significant, and CPS looks at that heavily. So if you're missing visits with your child, that is not going to be looked upon favorably for you. So please ensure that you visit your child as often as possible. Let's see. Discuss visitation. The more often you do it, the better it is. Always weigh the pros and cons of bringing emotion. Try and be decisive. Look at your long-term goal and the impact of what you're doing on your case. And it's no use, climbing uphill or fighting to be fighting. But, don't let anyone, push you or bully you around. You have to understand, when to bring emotion. You can't bring emotion every single time. It has to be something significant. So, please keep in mind as you're bringing emotions for visitation, is what I'm really talking about, or anything else, that it's done in a timely manner and as soon as possible. Please keep in mind, as I said before, motions have to be in writing, except as permitted by the court rules. But that's rare. Usually you have to give your opponent time to respond and a chance to understand what the grievance is or what you're arguing about. If you just spring it on them, they're gonna object and say, Your Honor, I wasn't given this ahead of time and I wasn't given a chance to prepare. And the judge is going to sustain it and going to make you go through writing it up and pushing it off. And the problem is that if he pushes it off, it might be 90 days to the next hearing. So you want to make sure you get that motion in correctly the first time. Unless the county attorney or another party objects, to an oral argument, if the attorney themselves, the county attorney or someone tries to make an oral argument, you too need to object. Say, Your Honor, I object. I wasn't given this information in advance. I haven't had time to prepare, and give all the reasons why that it's not favorable according to the juvenile rules of court procedure. So the judge technically should deny it unless it's good cause. If a judge is like denying something is wrong, you got to be a little persistent. Like, I understand what you just said, Your Honor, but, and then you need to have your court rules or your procedures. It may take several hearings to achieve the desired result that you want, but keep at it and you'll get it, especially as it relates to visitation. If you're going to request additional services, say there's a gap in service, I do know that certain agencies, they'll give you transportation money, they will help you with housing, they'll give you a top-up card for your phone so you can make the phone calls or you can make visitation. They will give you trauma services, parent mentoring, family therapy, support groups. So don't be afraid if you see there's a gap or you need something or your kids need something, don't be afraid to ask for it. And you can ask social services for it first. If social services doesn't give it to you, then you can go ask the judge for it by filing a motion. Anything that can be helpful or you feel may be helpful to address you getting your kids back faster or any issues there may be. For example, if you're doing drugs, a drug addict will never achieve reunification with their child if they're not addressing the chemical dependency issue. So if they give you a case plan that doesn't address your drug addiction or you going to like outpatient therapy or whatever, well, that's a skewed, case plan. That means they're trying to make you fail. You can't have a case plan about a person, being a drug addict and they don't try and stop the person from being a drug addict. It's like they're just trying to take their child. So discuss all that with the caseworker. Bring a motion to address any needs that aren't happening the way you feel they should happen. So the judge can review an order for other services. Most likely, if it's to help you get your child back, the judge is going to automatically order it. So if the social services doesn't give you a plan for treating your chemical dependency, you ask the judge is going to give you that plan. He's just not going to say, no, we're not going to help you. It's not what they do. So make sure you bring to the judge's attention any support that you've requested that they haven't given to you. So that's something else that you need to keep in mind. And ensure that all the services that are recommended by the case plan are applicable and appropriate to you. If they have your child for corporal punishment, say you spanked your child, and then in the case plan they say, we want you to do drug and alcohol tests twice a week. You're like, wait a minute, that has nothing to do with, my child, me spanking my child. So that's clearly unreasonable and inappropriate because it has nothing to do with why they have your child. So look at the UAs, look at evaluation and reevaluation, look at the treatment program, look at aftercare, any additional services. Look at that and see if or not it's appropriate for why they have you or your children. There are limiting services like certain assessments. They might have you do a psychological assessment or a diagnostic. So you can do a diagnostic versus a psychological evaluation, psychiatric assessments, medications that are needed. How often do you review that? So with any of that, it's better to get more than one opinion. If they say, well, if one doctor says, well, I want you to take this drug, say, well, I need to go to a second opinion first before I take any drugs or put anything in my body. So, it's something you should keep in mind when they're trying to do all these assessments. Is it the appropriate assessment? And if it is, how much do I want to limit it? Do I want to take the whole thing? Do I want to, try and do something else? So, it's a hard thing, but make sure, like I said, again, it's appropriate for you. Counseling services, if it's individual, couples, or a group, make sure that's done. If it's a day treatment program, just look at all of the things that are applicable to you as you go through your permanency proceedings. At the end of the court must review your progress in the case. So at the end of the hearing, every single time they're going to review your progress in the case plan, and they're supposed to do a formal write-up. The agency's reasonable efforts to do reunification, to put the family back together. The court is supposed to review that at every single hearing. If they're not going to put the family back together, the agency's efforts to finalize the permanency of the child. This child just can't be out there hanging in limbo forever. So they need to do that also. And in the case of Indian children, have active efforts going on to prevent the breakup of that child from its Indian family or its Native American family. So that's United States Code Title 25, Chapter 21, 1995, as it relates to Native Americans. Relatives, let me talk about that. So relatives can also take advantage of or be in the case plan, or your kids can be with the relatives. So, you can get them involved for support or for placement or for anything pertaining to you being successful in order for you to get the kids back. So don't just discount out, parents or relatives or any other support group or program. If at the hearing the judge finds that the child still needs to stay in foster care, the judge will let that be known and state why they feel the child should still be in foster care. If the parent is not maintaining contact with the child, then the court may either return the child to the home or keep the child in out-of-home placement for 6 months. A lot of it depends on what the judge finds. And I said if you're not maintaining, I meant if you're maintaining contact, doing regular visitation, that's what I meant to say, then the court can bring the child, let the child come home, or do what's known as trial home visits, or the judge can, stay that the child stay within the foster care for the next 6 months. It depends on the findings, and every case is different. So you got to make sure you present everything in the most positive light as possible. If the judge finds that you're not in compliance with your case plan, or you're not maintaining regular contact with the child as outlined by the case plan, and you're not doing visitation, the court will most likely develop a permanency plan, which will lead to the removal of your child, or TPR, termination of parental rights. They could consider identifying other relatives to put the child with, or file a permanency petition. So keep that in mind if you're not doing what you're supposed to be doing. Minnesota Statute 260.507. If they file a permanency petition because you haven't been doing what you're supposed to do, they got 10 days and have to have another admit-deny hearing, like in that first trial you had 6 or 7 months ago, because now they have to have another trial if they try and terminate your parental rights. You just can't take your child away without having a trial. And here again, the court determines whether there's a prima facie case. That means, like, on first look, it looks like you're not taking care of business, so we're going to take your child. Here again, allegations, they got to go and prove it. And it's very hard for the court or social services to prove to the court that you're going to be an unfit parent forever. That's very, very difficult. It's a very high standard. And parents don't realize how high it is. And a lot will, give up or voluntarily give up their kid for adoption or rights. And I'm just like, I don't know why anyone would do that. I would have to go down swinging. I would never, ever give up my child voluntarily. So according to the Minnesota Juvenile Court rules and procedures, 32.02 subdivision 5B, They have to give you, serve you with a summons that they're going to file this TPR, or if they can't find you, it's a service by publication. They can put it in a newspaper, but that's if you abandon your child. They have to do that, but 10 days have to go by, and then you have an admit-deny hearing like before. Then you're going to have a pretrial hearing, and a pretrial in your TPR case has to happen at least 1 week prior to your final hearing. In your pretrial, that's when you discuss your witnesses, what exhibits you're having, what discovery's been collected or what's still outstanding. Did you get the social worker case file, the guardian ad litem case file, the service provider's case file? Did you e-file the witness list, and an exhibit list to the court? So all of these things happen during your pretrial. At the pretrial hearing, you're going to discuss what's expected, how long the trial is going to be, like what's a conservative estimate of how long you think the trial is going to be, who the county expects to call its witnesses. That needs to come out. They should send that to you as part of discovery. They should discuss methods of testimony, whether it's going to be in person, orally, Skype. Are they going to stipulate exhibits that both the prosecution and the defense both agree upon? That means you and the county attorney are both agree, yeah, that should be an exhibit. The guardian ad litem, what are they going to say? What are they going to testify on? So that information is going to be there also. And, if there's any, potential settlement options, what people will do sometimes, they'll be like, well, we'll give you the 2 oldest kids, but we won't let the youngest one come back home, and things of that nature. I'm like, no, I want all my kids, so no settlement. But it could be a settlement is if you go to a treatment plan for the next 6 weeks and you do great in that treatment plan, we'll let your kids come home. So listen to what they have to say. Don't just rule it out, but, you're at the pre-trial stage, so you're about to have another trial. Minnesota 260C 103, termination of parental rights, voluntary or involuntary. Well, for me, it always has to be involuntary. I'm not voluntarily terminating my parental rights. So I don't understand that. I know people have done that, and they say, oh, well, they bullied me into it. They said if I don't terminate or give it my child, I'll never see it again. Well, once they do a TPR, you're never going to see your child again anyway. So that social worker just lied to you. It's happened to so many of our members where they were told they would get visitation with the child and things of that nature if they voluntarily terminated parental rights. And then after they did that, they never saw their child again. So never voluntarily terminate your parental rights. And the reason I say that is because the burden of palpable unfitness, meaning you being unfit for the rest of your life, is a high standard for the county to prove. It's like so difficult. I don't know how to prove that you're going to be unfit forever, because no one can predict the future. No one knows that. So they have to prove that you're going to be unfit forever. And 9 out of 10 times they can't. So I would take my chances and go to court. Most people don't realize that the county doesn't win that often, TPRs. And if they do, it's because the parent has allowed that to happen. So in order to make it voluntary, you must make it clear on the record that you're doing it voluntarily. But as I said before, I don't know why anybody would do it voluntarily. Minnesota Statute 260C 503, the permanency proceedings are required. The court shall commence those permanency proceedings within a 12-month time period if that child has not been reunified. That is the length of time that a child can stay in foster care in Minnesota. So that is something to keep in mind when you're looking at that CPS timeline that I went over before. So in order to prevail, the state has to show, they have to demonstrate on statutory grounds that the termination is clear and convincing and is in the best interest of the child. And that's hard, to do. Look at some of the case law in the PDF. I'm not going to go over it right now. in the welfare of RF is one of them, but I have other case law linted that will help you understand how difficult it is for them to terminate your parental rights. So in 260C.503, in the permanency proceedings, the responsible social service agency must ask to terminate your parental rights because it was like egregious harm, broken bones, or something of that nature. A sibling who was subjected to egregious harm, say you broke Danny's arm and Danny has a brother, well, they're going to take both kids at the same time. That's just the way the law is written. If one child's in danger, the other child's in danger also. Child is abandoned. If you abandon your infant, that's another way they can do a termination of parental rights, and also sexual abuse also. If you've committed multiple offenses against multiple children, that's something else they can do. Or if another child is subject to abuse, they're going to feel everyone is subject to abuse, and they're going to try and transfer. So if you had a transfer of custody or a TPR in the past, it's going to carry over to your next child or your new child also, if you have another child. So the social worker, 260.012, the social worker really has a duty to ensure placement and family reunification. So they really are supposed to be trying to do that. And you need to stay on top of them and make sure that they are doing this for you, that they've listed everything, that you're going to everything, so they can't come back and say that you're not doing what you're supposed to be doing. They're supposed to be making reasonable efforts, and if they're not, you can come to the court and say, Your Honor, they're not making reasonable efforts to reunify my child and I, and here are the reasons why, and here's all the motions I filed and all of the documents that support what I have to say. So that is something that you should keep in mind.